don't do it because you discuss it within a family. You go, oh, I don't want to talk about it. It's morbid. It's morbid. But you can leave chaos if you don't.
Look, a will is a legal document that sets out what you want to happen to your finances if you die. Now, certainly, if you're going to be paying inheritance tax, you want to do it and you want to think about it and who you leave to what. So whether you're leaving to your spouse, you're allowed to leave more in that sense because it's got a free limit there and they can then pass it on. But absolutely everyone who wants to dictate themselves what happens to their money when they die should do a will. Otherwise, you rely on the intestacy laws, which is where it's prescribed what will happen to your assets. And those depend on whether you're in England, Scotland, Wales, and Northern Ireland. They work slightly differently. Gov.uk has a tool which will tell you what happens to you if you die without a will. But just let me say, anybody who is cohabiting and not married or in a civil partnership, you really need to do a will. Do not assume that your house will pass to the person you live with. Common law spouse doesn't exist. Living with someone for 37 years with 6 kids, irrelevant. You're not married, you're not a civil partnership, you don't have rights. And more
hideously outdated.
Isn't it?
Well, so that we've now got that heterosexual couples can get a civil partnership for those who don't want to get married. But ultimately, a marriage or a civil partnership is a contract. You haven't signed a contract with the person you're living with. You need to sign some form of contract. If you don't get married or have a civil partnership, sign a contract about the house.
Yeah.
Right. But the other thing I should say is if you've got kids from a previous marriage and you've married again, and you want your kids to have some assets, they may not get it under some of the laws of intestacy, depending on how much assets you've got. So you really do need to think about this quite importantly.
What about power of attorney? How important is that?
Well, I actually think that's more important than a will. Let me explain why. Look, a will, you're dead, right? It's talking about passing money on to somebody else, and hopefully you're looking after them. Power of attorney says, if I lose my faculties, and 1 in 3 people have dementia when they die, people also get strokes. If I lose my faculties, I'm giving somebody else, in the event of that happening, power to use my finances. You might not even be able, if you don't do this, without going to the court of protection, which is expensive and costly, you might not even, they might not be even able to use your money to pay for your treatment.
Right.
Right? So I have a power of attorney, even though I've got no foreseeability of losing my mental capacity. I'm 46. I did it 7, 8 years ago. It is a good thing to look at. I know we're running out of time. I've written a full article that's on the website that explains more about this and how to do it and how to do it in the cheapest ways. But think about what would happen to you if you lost your capacity. It's not just for those in their 70s.
No. All right. Thank you, Martin. You don't want to think about it, but you have to.
Yeah.
All right. Thank you.